welcome to today's final panel in the launch series for the new Journal of Free Speech Law, which is brought to you by the UCLA Institute for Technology, Law and Policy, a collaboration between the UCLA School of Law and the Samuel Lee School of Engineering, whose mission is to foster research and analysis to ensure that new technologies are developed, implemented, and regulated in ways that are socially beneficial, equitable, and accountable. My name is Michael Karanikolas. I'm the Executive Director of the Institute for Technology, Law, and Policy. I'll begin by acknowledging UCLA's presence on the traditional, ancestral, and unceded territory of the Gabrielino Tongva peoples. We, again, don't have a ton of time for this fantastic panel, and we've got some great speakers, so the introductions will be brief. Eugene Volokh is the Gary T. Schwartz Distinguished Professor of Law here at UCLA. Nadine Strossen is the John Marshall Harlan II Professor of Law at New York University. Jane Bambauer is visiting affiliated faculty here at the Institute for Technology, Law and Policy, as well as Professor of Law at the University of Arizona. And we may be joined momentarily by Ash Bhagwat, the Butchever and Bird Endowed Chair for the Study and Teaching of Freedom and Equality, and Martin Luther King Jr. Professor of Law at UC Davis. So thank you all for joining us for this fantastic panel, and I will hand it over generally to our panelists to open the discussion.
Thanks, Michael. We confused Michael by insisting there's no single moderator of this one. So as Michael said, this is the last in this series of conversations with already published authors of the Journal of Free Speech Law. I put it that way because I think Eugene has already started planning a round of conversations with the authors that are going to be publishing with us in the future. But welcome everyone. If you missed any of the videos from the series, they are starting to be published piecemeal online, and we will eventually have one single library where you can access all of them. But it's our great pleasure to have Nadine with us, who wrote a really interesting paper on the relationship between free speech and anti-racism and social justice movements. So Nadine, could you spend the first 5 or 7 minutes describing the motivation for your paper and then what you argue in it?
Yes. Well, first of all, thanks to all of you for spending your precious time here talking about a subject that has been central to my advocacy and to my scholarship throughout my entire career. I think attacks on free speech as supposedly being inconsistent with equality goals certainly took off in high gear shortly after I graduated from law school way back in the 1970s. They came to a fever pitch in a case that many people will still remember or have heard of when I describe it with just one word, Skokie, when the ACLU famously or infamously, depending on your perspective, in the late 1970s, came to the defense of free speech rights of a group of neo-Nazis who wanted to have a peaceful demonstration in Skokie, Illinois, a municipality that had not only a large Jewish population, but many of whom were Holocaust survivors. At that time, that defense by the ACLU, which was a hands down winner in the courts of law, right, with one exception, a lower court judge in Illinois who was elected. I won't say anything more, but with that one exception, every single one of the many, many judges, federal and state, who ruled on that case, including the United States Supreme Court Justice, said, of course they have a right to speak regardless of their odious viewpoints. This is the bedrock principle that we now cherish as viewpoint neutrality or content neutrality. So easy a case as that was in the courts of law, it was really controversial in the courts of public opinion, including within the ACLU itself. The ACLU famously lost 15% of our members who said, I really, really support free speech, but I draw the line here. Now, I'm deliberately starting back in the 1970s, Jane, because what the initial prompt for writing my article that you kindly published in your journal was a critique of the ACLU. I should say 2 critiques of the ACLU that are very current now, as aired in an article for the New York Times that was written by a journalist I admire a lot, Michael Powell, in June. And interestingly enough, I read Powell's article. I mean, he referred to an identity crisis of the ACLU. I read him as focusing on critiques that the ACLU is not sufficiently strongly continuing to defend free speech for racists. But I have to tell you, I continue to encounter, including in debates that I did about that article, I continue to counter the opposite critique as well, that the ACLU is still doing too much to defend free speech for racists. And in fact, I want to put in the historical trajectory another really important milestone. In 2017, the ACLU defended free speech for Unite the Right demonstrators in Charlottesville, Virginia. And we got a lot of blame for the murder of Heather Heyer and the injuries that were sustained by dozens of people because people thought, well, if they hadn't been allowed to demonstrate, then the death wouldn't have occurred and so forth. So this just continues to be, and there are many other examples I could cite, the fights about hate speech codes when they were first instituted in the 1980s. Another example that I've also written about are struggles within feminism, starting in the late 70s, going through the 80s, and still, recurring now in the context of the Me Too movement. Do we have to choose between robust free speech, especially for speech with any sexual connotation, on the one hand, and gender equality and safety for women on the other hand? So I have, throughout my adult lifetime, grappled with the relationship between equal rights for women and racial minorities and others who have traditionally been marginalized and oppressed, and freedom of speech. To the best of my human ability, I try to be open-minded. I know we're all subject to cognitive biases. I do not think that free speech is absolutely privileged. More importantly, under constitutional law, freedom of speech is not absolutely privileged. So, if somebody could show that an additional restriction on some of this controversial speech, above and beyond the significant restrictions that already exist under our law, if somebody could show that that was necessary in order to promote equality or some other compelling goal, I would be all in favor of it. But all of the research I do shows that no matter how well intended, these added restrictions actually undermine the goal of social justice, of equal justice for racial minorities, for women alike. So that was, pretty much what I summarized in my piece, but I emphasized the really heroic, legendary crusaders for racial justice, including within the ACLU itself, who have taken that position, because in today's world, where identity is such a salient factor, I think it's really important to have people like Eleanor Holmes Norton and Pauli Murray, both of whom work very closely with the ACLU, including defending free speech for racists. And they, as pillars of the racial justice movement, believe not only that they are defending those free speech rights, despite the fact that the speech is by racists, but precisely because that adds legitimacy to the claims that they then make when asserting free speech for what was in their lifetime, and indeed in my own lifetime, a very unpopular cause, a very controversial cause, the civil rights cause.
Great. Eugene, do you want to jump in with a comment or question, or shall I go ahead?
I'm happy to leave it to you at the outset, Jane. Okay. I'm sure there'll be lots of things for all of us.
So first of all, to the audience members, I do want to let you know that we are paying attention to the chat. Feel free to type questions in, and we will eventually, hopefully, get to them. Nadine, so I'm wondering, first of all, actually, just picking up where you just left off, why is it, like, can you give some examples and then like an overall theory of why banning certain forms of hate speech tends to be counterproductive? And then also, I guess a follow-up question is whether the evidence for that is still persists even in the internet era, where racist, people with racist ideas can find each other more easily and congregate more easily and whatnot.
Yes, and this was the main research that was reflected in a book I wrote I wrote it in 2017. But I continued to gather examples, and just a couple of years ago, an epilogue was published that focused specifically on the internet, which continued to show that rules against so-called hate speech that go beyond the kinds of restrictions that are allowed in US law, when you can show in context that particular hateful speech, for example, constitutes a punishable true threat or intentional incitement to imminent violence and so forth. But when you get beyond that, as the laws in many, many other countries do, as the so-called content moderation standards that are used by the tech giants do, they're essentially using, at best, the kind of loose bad tendency approach that used to be used in the US, but at worst, they're actually just flat out viewpoint-based regulations that you just may not express any view that is considered to be demeaning, disparaging, et cetera. And the pattern is of now, I don't think anybody can show in a systematic way that of all the numerous cases, especially when you're talking about social media, I don't know of anybody who's purported to look at all of the instances of enforcement of hate speech laws, rules or laws. But the consistent pattern is that too many of the punishments, right? Too many of the takedowns on social media and too many of the enforcement actions legally in the countries that have these laws are punishing members of minority groups who were hoped to be benefited by the law. And I must say, I was rather surprised by this when I was doing the research for my book. I had advocated on the subject for a long time, but it had been a while since I had looked at the actual enforcement records. And I was really especially surprised, Jane, by the extent to which the United Nations and regional human rights bodies, activists within those bodies, were complaining about the enforcement record under hate speech laws, not at all from a free speech perspective, right? They were interpreting their own laws as being consistent with these looser restrictions on hate speech, but specifically from the perspective of what is good for human rights and what is good for the rights, especially of those who have traditionally been disempowered. Now, my view is that logically we shouldn't be surprised by these patterns, because once you loosen up the standard for restrictions, the so-called standard for restrictions, beyond the really tight kinds of concepts that exist in US law under strict scrutiny, or what's sometimes called the emergency concept, once you give more discretion, certainly if you define the restricted speech in terms of a disparaging or demeaning viewpoint, that just gives so much discretion to whoever is enforcing it. We should predict that discretion is disproportionately going to be exercised, not in support of dissenting voices or minority constituencies, but rather consistent with whatever the prevailing orthodoxy and power structure is in whatever the community. And this is a pattern that has existed in modern democracies as well as in in more authoritarian regimes. So to, give an example from the internet, since you specifically asked about that, when Germany enacted its really tough so-called NetzDG law a couple of years ago, the very first examples of hate speech that were taken down shortly after January 1st, the year it went into effect, were a couple of right-wing politicians. I consider their views odious, as the daughter of a Holocaust survivor from Germany, particularly odious. And yet, this was a very serious political party that got a distressingly high number of votes throughout Germany and at the national level. I think it's critically important to hear what their leaders are saying. But, the very next day, a satirical magazine that was mocking and lampooning the comments of these AfD political leaders was also taken down, as were artists who were also critiquing and satirizing the far right. So the problem is too much discretion, and we can predict that that's never going to be a friend to those who lack majoritarian power.
So it sounds like part of the problem is too much discretion. Maybe tangled up with that is lack of clear standards. When the idea when the definition of hate speech is murky, there tends to be enforcement that is not very sensitive to context. Is there a backlash problem? Oh, sorry, you can.
I'm sorry, I wanted to throw in one other factor here, Jane, and you're exactly right that I get what we would think of as due process and First Amendment standards of, avoiding void laws that are void for vagueness is very much at play here too. The Facebook Oversight Board has bound itself, or under its charter, it's bound to take into account a rule in accordance with not only Facebook's own standards, but also with the international human rights law free speech standards. And that to me is really interesting and really promising, because in the last few years, I have become aware in a way that I never was before of the big body and increasing body of speech protective jurisprudence within the UN machinery that is interpreting even Article 20 of the International Covenant on Civil and Political Rights and Article 4 of the Convention for the Elimination of Racial Discrimination, which famously requires signatory countries to outlaw hate speech. But those provisions have been interpreted incredibly narrowly as requiring that even the mandated restrictions comport essentially with not only strict scrutiny, that the restriction has to be the least restrictive alternative necessary to combat hatred or, promote equality, but also consistent with the principle you just flagged of it can't be unduly vague. It has to be very clear and precise and narrowly tailored. And I forget the exact number now, but a large number of the cases that the Oversight Board has ruled on have involved hate speech, and virtually all of them where Facebook took down under what it considered to be hate speech that should be restricted. And in virtually all of those cases, the Oversight Board said, no, under the UN standards, this is not hate speech. It's not, there are less restrictive alternatives that could be used, or it could be more narrowly defined and so forth.
Okay, so I also was thinking that, though, that another factor is the unintended consequences of takedowns or laws or whatnot. Is there good evidence on that? Like, do we know how people who are in a internet, a filter bubble already and are already kind of starting to slip in terms of their epistemic function, how they respond to takedowns? And there,
to the best of my knowledge, there is only anecdotal evidence. I've asked a number of social scientists, is there a way we could possibly measure and capture in a, a holistic way, a statistically accurate way, what the overall impact is, positive or negative. And I haven't gotten any positive responses to that. But there certainly are many, many anecdotes about people who, if they're not allowed to use a certain word, will then come up with a meme or, a dog whistle or something.
Like fixate on it, right? I mean, that's sort of
conveying the same idea. And we run into this in the all of the debate about so-called disinformation or misinformation, which to me is completely analogous. And by the way, why don't I throw into the hopper the third major kind of speech that is always demonized and singled out for proposed censorship by either government and or big tech, and that's so-called extremist or terrorist speech. And all of these concepts have that problem that you and I already talked about of the inherent vagueness and subjectivity, which means that some of the speech is going to go unpunished, and because it may morph into more vague terms that can elide the censorship, and yet may even be more pernicious because it's somehow sugar-coated, right, in a way that direct contemptuous racist vulgarity or a flat-out lie may be harder for people to swallow. It will be driven underground. People are driven into these filter bubbles where it's hard for law enforcement to detect them and follow them and monitor their plans for potentially the illegal activity. And it's hard for others to try to dissuade them, come in with counter perspectives.
Yeah, the one piece of empirical evidence I'm familiar with are the studies by Seth Stevens-Davidowitz, who wrote Everybody Lies, where it's a little different, but he looks at what people do, what they Google during, well, this was during the Obama administration, but during key talks that Obama gave on the subject of race, when the tone of the talk was a bit, was sort of shaming, or when it sounded like elites telling other people what to do and think, then the number of times that people searched for racist terms spiked. On the other hand, if race was discussed a different way, usually with, by describing positive examples of racial minorities doing valiant things, then you actually see the baseline number of racist Google searches actually goes down. It dips down below baseline, and so that, I mean, if we can infer from that, I'm not sure how much we can extrapolate, but there does seem to be that suggests there at least might be a significant backlash where it's actually sort of counterproductive, even on the terms with which the rules are designed for.
That's really interesting. And, again, going back to the Charlottesville incident, I mean, the racist speech there was just, it still gives me chills when I think about them chanting, "Jews will not replace us." And yet I think and again, I haven't seen any studies. I don't know if there could possibly be numbers, but my assumption is that, for every person who might have been won over to support white supremacy by hearing those odious chants, there were, countless others that were galvanized into anti-racist activism by it. I think it really ignited, such strong opposition throughout so many levels of society that is still having ongoing positive effects.
Yeah. Osh, welcome.
And I apologize for being late. I made a time zone error and double booked myself. So
I do that all the time.
Eugene or Osh, feel free to jump in. Otherwise, we have a question in the queue, but
let's turn to the queue, and then I'm sure Ash and I will have interesting things to say, or at least things to say.
Yeah, so I have a couple questions from Michael, but Michael, do you want to just go ahead and come back in and ask questions? or would you like me to? Yeah, go ahead. Okay.
Oh, sure, I can. Oh gosh, I have a lot to say, but I also don't want to. I want to be respectful on this. So I was the first question that I asked was around the efficacy of deplatforming and around efforts to use firmer measures to combat hate speech. And I guess I was I think I asked that question before Professor Strossen began talking about the platforms, because I was interested to know whether those same arguments transitioned over. But I do think that there is the experiences of the platforms potentially does change the dynamic around the potential efficacy, not only because if you're doing a proportionality assessment or assessing the costs and benefits of it, being deplatformed is not the same thing as being subjected to state action. There are very clear differences, and I think it's certainly there's a need for stronger guardrails to actions that could result in taking away somebody's liberty than deplatforming. So I would be interested to know whether how the calculus changes between deplatforming as opposed to prosecutions, and whether the efficacy calculus impacts that as well, because there are instances relatively recently where deplatforming has been reasonably effective at taking people out of the discourse or marginalizing people who one could argue should be marginalized in order to preserve a healthy democratic discourse. And the second question that I had is more about, so I'm a Canadian and a relative newcomer to the political discourse down here. Obviously, I'm familiar with some of the differences around approaches to speech regulation between Canada and the US, or between the US and Germany, what have you. I feel like there's a deeper question about the purpose of speech regulation and the purpose of structuring the public discourse the way that we do. And in my mind, one of the core values underlying that is this idea of supporting a robust public discourse in order to safeguard democracy, and the idea that freedom of expression is fundamental to protecting the democratic structure and what have you. I wonder then if backsliding in the United States and fundamental challenges to democracy in the United States serve to undermine that model when compared to a country like Canada, which has a more aggressive approach towards hate speech, and which, while not a perfect democracy, I think I would argue looks to be more stable and healthier as compared to the US right now.
I'm good. Well, first of all, Michael, I hope we can be on a first name basis, or I'm going to have to. Thank you. And thank you so much for those two questions. I have participated in many platforms with Canadian counterparts, including on hate speech, and I'm quite familiar with the Canadian jurisprudence, a lot of which I cite in my book, because I think it really illustrates the point that Jane made about how inherently subjective these standards are, even when you have the wisdom of the Canadian Supreme Court judges, including justices and lower court judges who have tried to elaborate on the standards. They're hopelessly vague. And I'm not going to remember the name of the case now. It possibly is the Bhagwat case, but I can't swear to that. One of the cases that went ultimately to the Canadian Supreme Court, I thought really illustrated the inherent vagueness very well. It involved somebody who was a religious crusader against homosexuality. He apparently believed sincerely that people would be condemned to hell if they engaged in that form of sexual conduct. And he was passing, quoting Bible verses that we've all seen quoted, passing out, I think it was 4 pamphlets, and it went through 3 stages of the judicial proceedings. One was an administrative tribunal, one was an intermediate court, and the other was the Canadian Supreme Court. Court. And I honestly don't remember which court came out which way, but one of them said all the pamphlets constitute punishable hate speech. A second one held none of them constitute punishable hate speech. And the third one said two are and two aren't. And so that kind of discretion to me is threatening not only to individual liberty and equality, but also to democracy. I'm not going to get into any kind of, you're talking about difficult empirical studies. I can't imagine comparing the health of Canadian democracy to that of US democracy. So let me just stick within the corners of my own country, Michael. Obviously, I'm deeply concerned about threats to democracy, but I always have to ask myself, as compared to what? I mean, yes, free speech can definitely be wielded in a way that threatens democratic values through lies, through extremism, through hate speech, through a combination of all of them, which I think came to a head in January and then January 6th events. But as compared to empowering government, which at that point would have been the Trump administration, but put that aside, empowering any government official to make these inherently subjective distinctions between the kinds of rhetorical overstatement that our Supreme Court has rightly said, in my view, are just essential and unavoidable if you're going to have robust debates, including about civil rights, right? It was, in a couple of important cases from the civil rights movement that the Supreme Court basically upheld the right to exaggerate, fabricate, engage in disinformation. Yeah, that's a little bit dangerous. And in that case, by the way, there was some violence that occurred, but to me, it's less risky, including to democracy itself, to interpose a judicial arbiter of truth. I recently reread the Supreme Court's decisions on the right to lie, the Alvarez case and some of the defamation cases. And, there was such striking language about in our government, we don't have a ministry of truth. Referring to George Orwell. And so really the best defense that ultimately keeps bringing me back to free speech is like Winston Churchill's famous aphorism about democracy itself. It's the worst form of government except all the others. And free speech is very dangerous, but to me, it's less dangerous than government censorship. Your first question, I'm sorry, I wasn't taking notes. Can you just quickly remind me what it was?
Nadine, can I jump in here because it's related to Michael's first question? So I suspect we are all in agreement on concerns about government discretion here. But
big tech question, yeah, sorry.
Effectively, what we have done is we've outsourced those judgments to social media.
Yeah.
Right? I mean, because Facebook makes decisions every day about what's hate speech and tries to pull it down. And I think Michael's question, his first question, was basically about how do we feel about them doing that and how do we feel about subsequent deplatforming? I'm really curious about your viewpoint because they do it, right, as a reality.
It's terrible. And thank you. Of course, that's such an important point, Michael and Ash. And I have thought and written quite a bit about it, although not nearly as much as Eugene and other contributors to your journal. And by the way, it's one of the reasons why I love your journal as a reader as well as an author, because you have such brilliant thinkers, including the two of you that I'm seeing now, the three of you that I'm seeing now. So basically, I look at the adverse practical impact, Michael, I agree that these tech giants have on free speech and democratic discourse, by the way. Yes, it's true, they can't take away individual liberty, but being able to deny a platform to the commander-in-chief of the United States, the leader of the free world, as he still was at the time, Donald Trump, that's pretty scary to me, not only because of Trump's own free speech rights, but because of the free speech rights of the rest of us who choose to hear his messages. And although it's true that Trump is not being denied liberty through that decision, it's physical liberty. It's also true that absent from, let's use Mark Zuckerberg as a comparison, because I've often surmised that in many important ways, Mark Zuckerberg is more powerful than Donald Trump ever was. Zuckerberg can't be sued for violating the First Amendment. Trump can be, and he was. Zuckerberg can't be impeached. Trump can be, and he was. Zuckerberg can't be not reelected. Trump was not reelected, right? Not to mention the checks and balances of other branches of government, the complete absence of due process constraints. So I think in terms of real world power, as a practical matter, to suppress the exchange of ideas that directly affect processes of democratic self-government, I'm terribly frightened by the power of these companies. And I'm really eager to read creative scholars such as the executive editors of your journal and others who have been published in your journal who are coming up with creative approaches. Because one thing I will say is I am supportive of the free speech rights of these private sector entities. I see them as, presumptively as exercising editorial discretion that the journal editors of the Journal of Free Speech Law exercise. You don't have to host all perspectives and all speakers. So I'm very attracted to any proposed solution that is not a heavy-handed proposal for direct government regulation of what the content standards should be. So I'm very supportive of potential technological solutions, requiring some kind of interoperability that would allow users. I'm very much in favor of end user empowerment, right? I'm very much in favor of so-called privacy type protections requiring informed consent and notice to users. I just had a situation of a very dear friend of mine, a very prominent person who had her account just completely taken down in a way that was very damaging, not only to her, but to others, and to protect her privacy. I won't go into more detail, but without any notice at all, without any explanation at all of what the reason was. She was very well connected and was able to pull strings to get it restored. But this was a wake-up call to her. She said, what do people do who don't have these kinds of connections? And when she was restored, she was never given an explanation as to, what had allegedly been wrong in the first place. And it really would have destroyed not only her whole private life, but also professional and those of many people who were dependent on her in significant ways.
Can I ask a question about the great deplatforming and January 6th? Because my read of what happened, especially with respect to, well, I don't know, I guess this is true for both Facebook and Twitter, was that there was great reluctance to in any way penalize President Trump until January 6th. And the reason that mattered so much was that the platforms thought that Trump got pretty close, maybe even on top of the incitement line. And that, so I guess my question is, first of all, maybe a reasonable argument is that the concept of incitement needs to be relaxed a little bit, given how easy it is for very powerful people like Trump, like InfoWars, to kind of have plausible deniability for a causal chain that they set in motion that results in some kind of great risk of violence or insurrection. The other possible argument that I'm guessing might be closer to where your head is that maybe even the current standard for incitement, narrow as it is, may be unnecessary, that in fact we should continue to prosecute those who actually commit crimes, but to treat listeners as autonomous agents who have their own responsibility to make wise decisions and not let responsibility flow upstream. Or I guess the other alternative is just keeping things exactly as they are. Where where do you think we should go?
You know, there are so many interesting threads that are going through this conversation. And one, I think the questions that were raised by Michael and by Ash, you know, are so difficult. I love the fact that there are so many brilliant minds that are working on these issues. But I think that one thread here is that, well, let me just start with the incitement, and then I'll may have time for something else. I've read commentary. Oh, well, let me just say this. One thread is that I do not think that the tech giants, including social media platforms, should be constrained to only restrict speech consistent with First Amendment or international law standards. I, as a user, would like to have the option to have a platform where I'm not subject to graphic violence. I mean, I hate it. My hands go, you know, so I think it would be nice to have other choices. We don't have to hold them only to the same standard that we would hold the government to. I think the argument for doing that becomes stronger the fewer choices you have and the more power that you know, monopolistic type power that's exercised by them. But strictly on incitement, Jane, I've lost track of who wrote what, but I know that First Amendment advocates and scholars that I respect, some have said Trump did satisfy, Trump and maybe Giuliani and some others did satisfy the Brandenburg standards. I've read that argument. I know Richard Ashby Wilson made that argument, among others. And then other people I respect, Suzanne Nossel from PEN America, you know, wrote explaining why Trump did not satisfy that standard. I'm a little bit agnostic because I haven't followed all the factual details, but it's certainly arguable, right? But I also agree with the more general point you made about incitement, which is why don't we just focus on those who actually committed criminal acts or threatened violence and lawlessness, and in addition to the criminal remedies, there are civil ones, right? I believe there are civil conspiracy lawsuits pending, and we just saw the successful conclusion of a civil conspiracy trial in Charlottesville, which, by the way, I support. I've written a couple of pieces about why I think that was completely consistent with the First Amendment, even though I also think it was completely consistent with the First Amendment for the right to demonstrate in the first place.
So, but if Trump is potentially guilty of incitement, doesn't that contradict your statement that it was inappropriate for the platforms to deplatform him, or are you suggesting he should be civilly liable?
Yeah, I'm so sorry. I didn't mean for the platforms to make that judgment. I mean, although I guess I would defend their right to do it, but I'm just very leery about what the consequences are. But I was not ruling out, and the people I cited were talking about potential civil or criminal lawsuits where the evidence would be carefully reviewed before a decision was made. And that's the other thing about the platforms. It's a little, you know, the prior restraint concept, it kind of, again, not literally, but the kinds of concerns that make us fear the prior restraints also come to the fore in that kind of effort. When you talked about why January 6th, I'm sure you know that other people are surmising that it's only at that point when Trump was certified as, when Biden was certified as the president, and when it was clear that there would be a Democratic majority in the Senate, that the platforms deplatformed Trump. So that was a cynical explanation that now that his—
oh my gosh, that had not occurred to me.
And I don't know what the motivation is, but the point is, when you have that much power and that much discretion, you can exercise it in a way that is politically motivated.
So Nadine, I wanted to ask you something that's related. It's not the topic of your article, and feel free to say that you don't want to comment on it, but it struck me as quite similar in some respects. So I totally appreciate your concern, which I think is quite right, about The problem being that we don't really trust the government to decide what's true and what's not. We don't trust platforms perhaps to decide that either. Maybe there's less at stake there, but certainly there's enough at stake, and there's reason to think that we should not, for one, welcome our new robot overlords. But I wonder what you think about libel law. Both the civil libel lawsuits, which of course some of them are kind of the very big picture ones, Dominion suing over allegations about its supposed participation in election problems, and may very well have a very strong libel case there. Conversely, President Trump having hoped to open up libel law so he could sue more people to do that. But beyond that tip of the iceberg, the rest of the iceberg is just ordinary people who are complaining that they've been accused of fraud, of sexual misconduct, of rape, of malpractice, and the like. And I'm seeing lots and lots of cases like this happening in lower courts. I'm seeing more of a push for platforms to try to do something about this as well. And what I've also been seeing is the survival and revival of criminal libel law. Looks like every year in the country, there are at least a couple of dozen criminal libel prosecutions in the about a dozen states that have such statutes. Then there are also some states like mine in California that don't have criminal libel statutes that are trying to re-import criminal libel concepts through the back door through other statutes. The sense being that there's a real danger, not just the public, but the individuals whose reputations might be ruined by false allegations, and that often a civil lawsuit means nothing if the defendant is judgment-proof, but the defendant is not jail-proof. So the only solution is to threaten defendants with jail for that kind of thing. Usually not prison, but jail in the sense that it's usually misdemeanor prosecutions. So I realize this is a somewhat different subject, but I think we have similar questions about, should there be any policing of truth through either the justice system or through online platforms? Should all be left to counter speech? Should we police truth more, or should there maybe be a distinction in policing kind of political truth versus sort of personal truth having to do with just ordinary individuals?
Yeah, this is a very, very important subject, Eugene, and I'm not at all, I know enough to know how little I know, and I really do appreciate reading, including in the Volokh conspiracy, about everything that's happening on the defamation front. My own very strong inclination is to be nervous about criminal power here. And I was shocked. I thought criminal libel was something that had been declared completely unconstitutional. So I was surprised to learn from you, from your writings, that it exists. The last time that I looked into this very seriously was a really long time ago, when I was a young lawyer and I was debating the then Attorney General of Australia at their equivalent of the American Bar Association convention, because they had not adopted the Sullivan standards. To my knowledge, they still haven't done so. And I did a lot of reading then, and it seemed to make sense to me, and it still does, that the speech protective standards that we have, even for public officials and public figures, were actually in some ways being criticized as the worst of both worlds. Because by shifting the issue to the intent on the part of the journalist, it was requiring, and by allowing discovery into their research, it was felt that there was too much intrusion into the journalistic process anyway, that yes, you weren't ultimately being held liable for defamation, but you were having to pay so much money for your lawyers and go through such a litigation burden and intrusion into the journalistic process. So it was bad. It wasn't good for the journalists, even with this really ostensibly speech protective approach. But it also wasn't good for the plaintiffs, because, they didn't care about the intent on the part of the journalists. What they really cared was having their name cleared. So a declaration of truth or falsity. And I remember at the time, Eugene, reading scholars who did specialize in defamation from very different ends of the political spectrum saying, maybe the better approach is to just have, to have a bifurcated proceeding. And the first would just be, is it true or false? And the penalty would only be a correction to the record. Now, as I say, I haven't thought about it in depth for a long time, but that's the last time I did, that's where I came out.
Let me actually push back on a little bit. I suspect I'm saying what Eugene was about to say, which is I think that the world as it existed before social media and the world as it exists today, which is a relatively young world, just 10 years old, 12 years old or so, is really different. And the reason is the word journalist has kind of lost all meaning, right? I mean, back in the day, defamers tended to be journalists because no one else had the ability to broadcast. But today, I mean, the major thing that's happened with the growth of social media is everyone is now a broadcaster. Most people who post on social media do not have any journalistic ethics whatsoever. They don't do, and they may well be deliberately engaging in falsehood. They're not going to defend a lawsuit because many of them don't have any money. They're not going to hire a lawyer. So the question then becomes, and this is, I think it's related to the hate speech question as well, which is the reality is this sheer volume of hate speech simply looks different today than it did even 20 years ago because of the ability to broadcast. And while though there are limits on what you can do on Facebook and Twitter, there are other platforms like Telegram and 4chan where anything goes. And maybe there is, for example, a correlation between the huge spike in hate speech against Asians and Jews in particular in the last 2 years and 3 years, and the huge spike in hate crimes that we saw last year as well. I don't know. I mean, it's very hard to empirically do that research. But so do you think the internet changes your perspective on this?
It really doesn't, with the greatest respect, Ash, and I'm very open-minded and I welcome anecdotal evidence and correlation, but I'm very skeptical about claims such as, there's been a huge spike in hate speech, or especially there's been a huge spike in hate crimes, because especially the organizations that follow these matters, including the Anti-Defamation League and the Southern Poverty Law Center, are the first ones to complain that the data is just woefully, scandalously incomplete. Most police departments aren't even keeping records of hate crimes at all. So even on the basic question of, how much is there and what's the trajectory, I'm very open-minded about that. Of course, there's too much. One hate crime is too much. One incident of a hateful expression is too much. That's enough for me. But for me, then the relevant question becomes, we can online we can communicate more of everything. We also can communicate a lot more counter speech. We also can counter the defamatory statements with corrections much more easily. We also can counter the disinformation with accurate information much more easily. And so is there a net adverse impact that's greater than any net adverse impact of any kind of controversial speech in the offline world? To me, the jury is very much out on that. To the point that people who don't have journalistic credentials, I would hope that would make the listeners much more skeptical. Just because person X says something defamatory about person Y, I would hope that most audience members would say, why should I believe that? In fact, I think studies that I've been reading or polls that I've been reading suggest that people are actually becoming quite skeptical of professional journalists, right? Sometimes with very good cause, that just because somebody has journalistic credentials doesn't necessarily mean they're behaving in a way that viewers would consider to be ethical or credible. So everything I'm saying, I realize comes down to one solution that I hope is not a solution, but one constructive step that I hope everybody can get behind, which is, it sounds so old-fashioned, but it's more new-fashioned and urgent than ever. Critical media skills, right? literacy, have the appropriate degree of skepticism about everything you hear people say, including what I'm saying, but not so much skepticism that you completely lose all trust in major democratic institutions, right? Including the importance of the so-called fourth branch of government and the watchdog function of all kinds of journalists, not just those who are professional. And here I'm just as one of the silver linings to the cloud of the racist speech in Charlottesville was really fueling up and galvanizing, I think, an unprecedentedly fierce, vigorous anti-racism movement throughout this country. The same thing has happened, or parallel development has happened in light of concerns about disinformation and misinformation online. It just seems that programs for teaching literacy and critical reading skills and online fact checking and researching are sprouting up all over the country at every level of education, including the lowest levels. And I think that's, ultimately, we're never going to be able, even with the strictest censorial measures, we're not going to keep all hate speech, all extremist speech, all misinformation and disinformation off these platforms. That's impossible. So we have to inoculate people against the adverse impact, either create in them a desire not to ingest that kind of material in the first place, or to not be adversely impacted by it in the second place. Better yet, to do something constructive, to speak out against it in the third place.
So I wanted to follow up briefly on that. First, I totally agree that it would be great if people were more critical in evaluating things, and maybe we could move that a little bit. The problem, of course, is that people don't invest as much effort in learning anything as outside of what they're needed for their jobs, regrettably. So hard to see that they'll do that much here. One way of kind of thinking about what Ash was saying is the following kind of cynical sounding framing, which is, it used to be that we talked a lot about free speech and free press, but the freedom of the press belonged to him who owned one, to quote A.J. Liebling. The bottom line is ordinary people didn't have much access to the media. Who had access to the media? The elites. Now, to be sure, lots of them had their own racist views and various other views, but it was at a time when that was mainstream opinion, and it couldn't have been suppressed in any case. You wouldn't, in the 1920s, you wouldn't have anti-hate speech laws because there was so much racism among elite opinion. So for a while, for a long time, because of these technological and economic constraints, ordinary people couldn't speak much, only the elites got to speak, and maybe we kind of liked that because the extremists were, by definition, marginalized. Now we got what we asked for. We got genuinely free speech and free press in the sense that people can speak for free. And now maybe we don't much like it, or at least many people don't much like it. Maybe all of us don't much like it in some respects, but at least some people are thinking that that's reason to try to reinstitute some sort of constraint that we used to have before, but just we pretended it wasn't real constraint. What do you think about that? Is it just, I realize that's a very elitist perspective, but I wonder if that's sort of what's being reflected in a lot of the concerns.
That's so interesting, Eugene, because I process what you said as an anti-elitist perspective, because I heard what you were saying as critical of that perspective. So let me just...
I'm critical about it, but also I can't just sort of say, well, that's an idiotic view that they're saying. No, I sort of see the point of it.
I see the point of it, but I'm not sympathetic at all. And in fact, I have quoted A.J. Liebling, because I think he really did have a point when he said freedom of the press only belongs to those who own it. And now just about everybody, not quite, we still have the digital divide, but we're infinitely closer to that ideal of just about everybody having a printing press in their pocket. And I am all in favor of that. I think we can't, in fact, this brings me back to the essay that I published in your law journal, one of the reasons why I think there is this integral interrelationship between free speech and equality rights is that because the ACLU has been criticized from one quarter for doing too much for racial justice, and supposedly that's not, you should be doing more for free speech. But to me, you can't have meaningful free speech unless it is something that can be meaningfully exercised by everybody, including those who have lacked the educational and technological and other financial resources. This is the elite that you're talking about, Eugene. And so I think it's really important and consistent with liberty, equality, and democracy, all three, to give voice to those who were previously voiceless. And yes, we may disagree with what they say. We certainly want to provide education that would expose people to different perspectives. And but I think to me, this is progress on the free speech front.
There's also, of course, the problem of how to pick the gatekeeper.
Exactly. Exactly.
If the rest of the world agrees I can be the gatekeeper, I'm all on board. But otherwise,
Right.
Yeah, right.
I mean, I saw much positive in Martha Minow's recent book, but as I told her in a panel, I disagreed with part of it, which including her salute to what she calls the golden age of, the big three networks. To me, that's the antithesis of a golden age in comparison to the seemingly infinite array of choices that we have now.
Well, I think, one reason to see that as a golden age, or maybe the reason it's easy to see problems today is that they are more visible, right? We can actually get access to the numbers of people who have racist beliefs, for example, and it's hard to compare that to the past. But I guess sort of striking at the source of the tension among the ACLU friends and members, I think is something that is actually a tension that the Democratic Party is more generally working on right now, which is whether to commit to, freedom to access the means versus equality of outcomes, or I guess equal access to means versus equal outcomes. You see this play out not just in the free speech context, but in all sorts of, hiring, every possible outcome that there is measured and debated in these terms. So I guess what's your how do you think the ACLU is going to resolve that debate, or what can we expect? For those who look at speakers and say, geez, marginalized voices are still marginalized in the sense that there's still a lot of nasty speech out there. They don't participate at the same levels as elite, well-educated white folks. Is the commitment to sort of civil libertarian approach to these things going to survive?
That's impossible to predict, Jane, even if I were actively involved in ACLU's leadership, which I'm not. I'm a member of the National Board of Advisors, which, occasionally we get asked for or provide advice, but we're not involved in the day-to-day governance. But I can say this from my past involvement and from reading the history of the ACLU is that these debates are perennial and have gone back to the beginning of the organization as emblematic of debates that go on in other quarters. You mentioned the Democratic Party. So for example, the fairness doctrine, right, which was supposed to, a government policy that supposedly was mandating, among other things, equal treatment of certain controversial subjects. There were deep debates and divisions within the ACLU throughout the entire history of that doctrine, with the very strong factions opposing that controlled effort, and others taking some supporting it and some opposing it from a more libertarian perspective. So I assume that those debates are going to continue, and at some points one will be ascendant, and at some points others. I can't go beyond that.
Okay. Well, thanks. We've burned through our hour, and it was fun and fascinating, as we all knew it would be. So I can't thank Nadine enough. Eugene or Ash, do you have anything to add as we come to the close of the
Just
panel.
many thanks to Nadine for joining us and for publishing her article with us.
Oh, thanks to you. And I really have to say, I love your journal. I love the fast turnaround. It is, you have spoiled me for publishing anywhere else. So I'm going to come back.
Excellent. That's a great way to end.
Yes. Thanks again. All the best.
Thank you.
Bye.
Bye-bye.